Well, good evening. Thank you very much for coming, and welcome to 39 Essex. First of all, can I thank Emily Formby and 39 Essex for hosting us all this evening. Welcome to you all online. I hope you can hear us clearly.
They're looking at you that way.
They're looking at us that way.
So yeah.
Excellent.
Yeah.
So welcome everyone online. A little bit of housekeeping for those of us here. Those of you on the right-hand side of the room should leave via the side door and exit by the back stairs. Those of you on the left-hand side of the room should leave via the centre door into the corridor, using the stairs in the reception area where we came in. The assembly point is Bream's building, opposite the front of the building.
Okay, that makes absolutely no sense at all. I think if we have to go, we'll go out that way and we'll just follow the side. Yeah. So really don't worry, but follow us and we'll take you out if we have to.
If you need Wi-Fi whilst you're here, it's 39 Essex-guest. Password is 39 London, capital L. If you take any pictures, share and tag. And at the end, there'll be some drinks. And I'm sure Emily will escort us accordingly. On to the welcomes. I welcome this evening Her Honour Deborah Taylor and Tamarind Ashcroft, both from the Medical Practitioners Tribunal Service, a body that makes independent decisions about whether doctors are fit to practice. A little introduction about Deborah. Deborah has the fortune or misfortune of having been my pupil mistress or pupillage supervisor when I first came to the bar 25 years ago. She herself was called to the bar in 1983 and joined the then 2 Crown Office Row following completion of her pupillage, practised in a mixed common law practice, and I know when I was her pupil, a mix of prof leg, high value personal injury litigation, but also some construction work. Deborah became a recorder in 1999 and was appointed to the circuit bench in 2005, became a Deputy High Court judge in 2013 and sat both in the Court of Appeal Criminal Division and also in the Administrative Court. Deborah became the resident judge at Southwark Crown Court in 2017 and held that role, including being the Recorder of Westminster, until her retirement in December of 2022. Deborah took up her appointment as chair of the MPTS on the 1st of March last year, 2023, succeeding Dame Caroline Swift. And the very brief resume of her career will, I'm sure, show you why she has the credentials to lead such an important organisation. Deborah and Tamarind are here tonight to tell us all about legally qualified chairs, what that involves, how interesting that is in terms of the variety of work. And thank you very much, both of you. I should say Tamarind Ashcroft is the head of operations at the MPTS. So I'm hoping that this will provide everyone with an opportunity to find out a little bit more about the role, what it involves, and ask any questions, however stupid. Deborah.
Well, no questions are stupid for this purpose, but thank you very much for inviting me. This is a joint event between PIBA, PNBA, and the HSBA, LA. So I'm delighted to be able to talk to as many of you as are here this evening, and I think it's also going to be recorded and go up on the website. The purpose of this really is to give a bit more information about what we do at the MPTS. Some of you may remember the Shipman report. The MPTS was set up following that as an independent tribunal, although it is obviously connected within the GMC, but the decision-making, appointment of members and the training of members is all independent. And we're very keen to stress the independence of those who are on the tribunals in making their decisions and to encourage that. The MPTS runs 2 different types of tribunal hearings, but we are actually recruiting this time for medical tribunals. That's the full tribunal rather than the interim orders tribunal. Some of you may already appear in the tribunals, but others may not. But we have a very wide range of work. I think some people think that it's all medical. But when I was thinking about doing this event, what occurred to me is that we are, in a sense, in the centre of a Venn diagram of all of your organisations, because we have regulatory, we have public, and we have a bit of crime-related work. But right in the centre is the regulatory side of it that we do. So when I say that, really what I'm talking about is, for example, we get cases where doctors have been involved in protests, Just Stop Oil, for example, in being online talking about COVID and vaccines. So there's an element of free speech, all of the public law aspects of that. There's dishonesty, both in their practice and outside their practice. There's sexual offences inside practice and outside practice. So really a very wide range of work. Not just medical. There are, of course, clinical cases, but I have to say that the purely clinical cases are a very small percentage of the work that we do. What we're more likely to see is cases where there is a clinical error, and there's also an element of alleged dishonesty because there's been a cover-up or something has happened afterwards. So it's a combination of all of those types of behaviours. And it's really very interesting. I, as you've heard from Victoria, used to do a range of work. I used to do professional negligence of architects, engineers, and I also did clinical negligence and personal injury. So for me, coming out of crime, where I'd been for quite a while, I could see that the range of work would be very interesting to all of you in your different organisations, because it gives an opportunity of using the background knowledge that you have and experience, but in a different field. We're obviously not making decisions in the same way as the courts would, but really would be deciding very important aspects of law and also the facts, which really affect people's lives, both the doctors who are before the tribunal, but also those who have made complaints about the doctors. So it's a really interesting variety of work. Just stepping back, we have 3 people sitting on the tribunal, so it also gives you an opportunity of sitting with a lay member and a medically qualified member. And it won't necessarily be someone who's medically qualified in the same field as the doctor who's before the tribunal. But what it means is that you have with you, as the legally qualified chair, 2 other points of view, and you all feed into a collective decision. And I think that this is a very important aspect of the work that we do, because some of you may have seen the press, and sometimes the doctors contend that some of the decisions that we make are not ones which they agree with. But at the same time, there has always been a medical member sitting on the tribunal and someone who is involved in the decision making. And so you sit with interesting people who have different backgrounds, and your role would be, as the legally qualified chair, to advise on the law, but also to ensure that the proceedings move along at a fair pace, that they're fair, that they're open, and that the decisions you made are reasoned decisions. So there's quite a lot in that. In the past, there was the legally qualified chairs the chairs were not legally qualified, and that's a relatively recent change. But it's one which I think has been very effective. And more and more of the cases that we do are complex cases. Some of you may have read that there are procedures which are being introduced for anaesthetist associates and physician associates, where the GMC will make a an offer, as it were, for an accepted outcome as to how the case proceeds. And what that may mean is that it's the really far more complex cases and important cases that come through to a tribunal. So what we are looking for in appointing 50 new LQCs in this current round, which is, I think, coming live Friday, it is people who are interested in dealing with this wide range of work and complex cases in a setting which is not perhaps as, I would say, adversarial as some of the court proceedings. That's not to say that we don't have some of the features which make sitting in courts both challenging and interesting. So we do have doctors who represent themselves, we do have vulnerable witnesses, but all of that is experience that you would gain in a different environment to that where you either practice yourself or may sit. So perhaps I can just go through some of the requirements. We usually require at least 5 years experience. So you don't have to have sat before. We give very good training. There'll be training which is 4 days a year. That's the induction training. There's also webinars and a lot of circulars sent out to read on and updating our tribunal members on legal cases which are happening at the moment. Our hearings take place both in Manchester and virtually. At the present, I think we have for the hearings, we have about 60-40. It's more in person than not. All the interim orders tribunals are now online. But we would expect you to be available to come and do a hearing in Manchester, which the requirement is at the moment that you would be available to do a case which would last between 5 and 10 days rather than just a single day here and there. We do require those who are applying to have an ability to offer to sit for at least 35 days a year. We certainly won't promise to provide that, but to offer to sit for 35 days a year. But I think the key thing is that you have to be available for a minimum of 5 to 10 days for these more complex cases. I have to say it's not going to make you rich. The daily fee is £525 for the legally qualified chair, but you also have your expenses. So standard class travel, there is a very nice dining room at the hearing centre where your food will be provided for you. You have overnight accommodation at GMC rates, and subsistence that's also provided. So you would get your expenses. And also the ability to come to glorious Manchester, which was totally unknown to me before I took this job, but I really have come to like it quite a lot. It does rain quite a lot though. But the real, I think the really attractive aspect of this, and I speak not only as someone who's done all of the types of work that you do, but also as a former Judicial Appointments Commissioner, is that this is actually a way of doing really important work, which perhaps is in some cases equivalent to High Court work, but at a tribunal level. It's interesting, you're in charge, and we're also going to introduce an aspect of case management, which will be done by the LQCs, which I think is not really available to those who are sitting except in the High Court. Perhaps you do as recorders at the moment. So it's varied, interesting and important, and I think highly enjoyable work. So I've given out today a sheet which sets out what the fees and expenses are, availability and so on. The application forms have to be submitted by midnight on the 15th of July, so you'll all be staying up like we used to do for when the new Harry Potter came out, midnight on whatever night. The applications will be sifted by the 19th of August. Between the 28th of August and the 6th of September, you'll be asked to complete a case study virtually within an hour of being issued the instructions. A notice of the date will be provided if your application progresses to that stage. And between the 9th of September and the 2nd of October, you'll attend an interview via Teams, including a presentation based on the case study. And then successful applicants will be invited to complete their induction training on various dates between January and March 2025. So this is the timetable, and I'm really keen to encourage people who have experience of being in the courts and seeing how cases are progressed, because one of the things that we are keen on is that you are able as the LQC to keep control of the case. We have timetables and you're all used to sticking to that timetable or trying to keep it moving. So that's another aspect. There are decisions to be made about whether people are excluded from aspects of the hearing for a period. There are decisions to be made about how witnesses are to be heard and disclosure. All of those things may crop up in the course of a hearing. So those would be decisions which you would be working with your fellow tribunal members to decide. So really, I think that's all that I had to say about the role. I don't know whether, Tamara, do you want to add anything?
I think you've covered it broadly. For me, what I've seen probably in the 11, 12, 13 years that I've been in post is people join having never had any judicial experience. They gain that judicial experience in a very supportive environment. I'm on the end of have been on the end of the phone to a number of legally qualified chairs today to assist them and bounce ideas off them before cases, etc., if they're thinking about how they're going to approach things. And then what I have then typically seen is that actually after a period of time, when you've got comfortable in that role, I probably lose about 10 legally qualified chairs every year to full-time judicial appointments, which I think is probably a balance of them understanding and actually really enjoying the work because they've actually developed that interest, but also demonstrating what we're able to provide for them to assist them in that career path if they haven't got that judicial experience already. So I think it's a really good platform, and as you said, Deborah, that ability to work with two other people who are equally making decisions alongside you rather than it just being solely your responsibility is quite a comfort as well, I think, in those early days. So very much a good sort of platform to start your judicial career.
It is a very supportive environment. Having come from the harsh environment of crime, I think that one of the things that I noticed most and was most impressed by when I joined the MPTS is the care that the MPTS staff take to ensure that everybody is supported and that you have everything that you need. There's a lot of circulars, as I say. If you need any advice on time or those sort of things, it's always available. And Tamara and her team and the case management team work very hard to support you. But I do think, as Tamara says, that we do lose a lot of people to the bench. And I think it's something that you can do alongside being a recorder, because I know that it's very competitive now to get a Deputy High Court judge role. But in fact, it seems to me, if you're sitting as a criminal recorder, this gives you another branch of experience which you can add, and it involves quite a lot of quasi-civil matters. One of the things we're trying to do at the moment is to get a power of contempt for our hearings because of the online nature and the possibility of people interfering in proceedings by either identifying people or taking photographs online, those sort of things. So you can see how it crosses over and it is interesting from that point of view.
And another bonus, I think compared to some regulatory bodies, we have tribunal clerks, the sort of administrators within the hearing room that will assist you in drafting. So if that's not something you enjoy, having somebody who is able to listen to all of your discussions, your reasons for why you've reached decisions, they produce some very lovely first drafts for you to then work from that point onwards, which for me I think would be a real sell.
That was actually one of my questions, which is who's the person who writes the reasoned decision?
Well, the tribunal clerk will provide the first version for you, but it is your decision.
Yes.
So you as a tribunal. And so if a legally qualified chair has a particular stylistic approach they want to take, they want to draft it, that's up to them. But they will have someone there to be able to provide a version that they can sort of edit from. I know I do my best work when I'm editing other people's work rather than writing afresh myself. But obviously your fellow lay and medical tribunal members need to agree the determination as well. So you'll get them to be a fresh pair of eyes, checking punctuation, reasons, etc., making sure it represents the whole view.
We also have templates as well, which help you put it into the same format as as all of our decisions, so that someone picking it up will be able to just read it in the same way. So it does help. Good. Well, perhaps we could ask if anybody has any questions. Dr. Victoria. Yes. Oh, I'll start with you because I just saw your hand first.
So there are 50 appointments you're looking to make this year, and you explained it to a degree by saying you lose about 10 people a year to judicial appointments. When's the last time you looked for this number of people, or why are you looking to?
2022 was the last time. So we take people on for a 4-year plus 4-year term. 8 years is a lot to commit, and your careers will change a lot in that time. So we have some people who might sit for the full 8 years. I spoke to somebody earlier on who's been doing it for 8 years, and they intend to reapply because they are enjoying the role that much. But other people, obviously, during that window, they will move on, perhaps retire, perhaps go on to salaried roles. We probably have at any one time maybe about 100 legally qualified chairs. So we have a pool of about 350 tribunal members in total. And obviously we need about a third of them to be legally qualified to account for the tribunals that they're sitting on. But most people who are doing our work do have other day jobs. So if we're only going to sit for 35, 40 or so days a year, we need a large proportion of people to offer the flexibility to come in.
I think also there was quite a few people who held over during COVID. So we have people who went beyond the 8 years. So quite a lot of those are now leaving, which is what accounts for the large cohort we're looking for. So, sorry, I think you were next.
Well, two boring questions about practicalities. How much notice do you get of sitting dates, and how long are you expected to, or how quickly are you expected to produce the decision?
So in terms of notice, we write out 3 times a year, forced for the next period. So if we're writing out around, I think about now they're doing it sort of June, July time, that will be looking at sort of the back end of the year, sort of October, November time, and sort of that third of the year sort of at that point. So you've probably got a lead in time of sort of 4 to 5 months. Some people, if they want to, give their availability effectively for the year in advance and sort of indicate that way. But you can also pick up short notice cases. So if you have a dropout in your own calendar and you're getting emails from us saying, we've got a hearing that's just cropped up where someone's pulled out, are you able to sit? Then you can pick up extra work like that. In terms of how long for the drafting, well, it depends on how long the hearing's listed for. So if it's a 5-day case, we're actually making distinct decisions at each stage. So there's a facts impairment and then sanctioned stage.
You don't reserve judgment, except at the end. It's done actually internally in the proceedings in these three stages. So there's the facts stage, so you make your determination on the finding of fact. There's then the impairment stage as to whether the doctor's fitness to practice is impaired, and there's another determination there. And then there's the final sanctions determination. So that is all done and accounted for in the sitting period. So, you'd be writing for a day.
Yeah, so it's the then and now and the,
Yes.
So there's no hanging over. You're not putting
You don't
having
have
to travel back from Manchester with your thoughts in your head and then forget about it. So you're doing it then and there.
No. Yes, you're sitting back.
How much preparation time is there usually with the cases of say 5 to 10 days and then?
Again, it probably depends about the case type, doesn't it? So Deborah's
Yes.
talked about some of the different types. You have a case about sexual misconduct, and there are lots of different issues that have cropped up. You might have a lot of witness statements to read, but if you've got a conviction case, you've just got the conviction charge, which would be much simpler to prepare for.
And do you get any reading in time on day one? And if not, do you get any payment for reading in time beforehand?
Yes, so preparation, there is preparation fees, because you also might just need to remind yourself about the Medical Act and the rules that go with it. So any preparation work that you need to do, there is a fee. Deborah said very nicely, you don't get rich. So they're not huge fees. We are paid for by doctors' registration fees. So none of the fees are sort of particularly great. But you also will have reading time within the hearing to an extent. And if there's downtime, you can prepare for later stages, etc.
Yes, I mean, we do actually, I'm not saying this to score points, but we do actually pay more than the other health regulators, if you're thinking about it in that way, but less than if you're sitting as a recorder. So, yes, any further questions? Yes.
Yes, my question was when you were saying 4 and 4, so it's a 4-year appointment. That then, do you have to commit to 8 and you're told if you're good enough after 4, or everyone mutually decides after 4 if you want to apply again?
You can leave at any time you want,
Right.
in fact. You can give notice, but we would like, it is a 4-year appointment initially. But obviously, if you found that you took up an appointment of some kind, then obviously we wouldn't hold you to it. And people do leave. If their circumstances change, they move, whatever. Yeah.
Just on the pre-reading, so would the other 2 members also have read in? So you get there on the first morning, you'd all have a shared level of knowledge.
What we're thinking about at the moment, as I said earlier, is that the LQC may very well do the last case management hearing. So that would be with the parties in the same way as you all do case management hearings coming up to a trial, what's still outstanding, making sure the timetable is set. And then, all of that will be done, and the bundles will be provided to everybody on the tribunal. So they would read them as well, the other members. Yes.
This is a potentially stupid question, but I'm taking you at your word when you said there were none. Would it be problematic if you were somebody who acted for example, the professional standards authority?
I think we would need to think about it in terms of conflicts of interest. And
I think it's an individual basis. I mean, some of these cases, I think it probably wouldn't be a problem if you acted for them rather than you were a member of the
so you were meaning if the professional standards authority was appealing a decision?
I mean, obviously you couldn't be instructed by the PSA to appeal a case in which you were the legal chair. But if, for example, so I do work for PSA on occasion. Would that be a problem if I do sometimes advise on whether or not to get a GMC?
I don't think for us, but I would probably question I'd probably question sort of whether or not you should be doing any MPTS cases for the PSA because of the perception potentially.
But they only appeal about 2 cases a year, I think, from us. So I don't think it would really arise very much. But I think it would probably be worth just checking that if you thought about it, that the PSA wouldn't have any difficulty. From our point of view, I don't think there really would be a conflict.
What proportion of the tribunal decisions are appealed? I'm just thinking because
it's a tiny number. Actually.
It's interesting because if you're in a group, you're a 3, and you're reaching their shared decision making. What might put some off is if I'm part of that, will I end up in the admin court being judicially reviewed? But presumably that's the next step up, is it? An appeal is to the administrative court.
Yes, so I think there's a question of appealed and appealed successfully. So appealed successfully, really, really small number.
Tiny.
But if your decisions are appealed, it's your cabinet responsibility, so it's your joint decision. So you wouldn't have to then go and appear before a judge yourself. We use our internal legal teams to defend the matter. So at the point that you've written your name on the determination and signed it to say that's the tribunal's determination, you can walk away. What we do let you know is we tell you whether or not your case has been appealed, and then we let you know the outcome, because most people are quite keen to know and have that smugness normally that they have not had it. But you draw the line at that point, so you're not involved in the proceedings if they are appealed.
And also, I don't know whether you've seen any press reporting of the sort of case that we do. It's very, very rare that you mention any of the tribunal members by name. In fact, I don't think they do in the way that they do mention, for example, judges.
Yeah, okay.
Because it's a tribunal. But as Tamron says, it's a tiny percentage that is successful. I think last year, something like that of all the cases that we do, and they were the sort of cases that you would have expected there to be perhaps a differing view about the sort of things that people would appeal that way.
Sanction, for example.
Well, the sanctions are really to protect the public. That's the important aspect of it. They're not punishing people. So it's really deciding what's necessary to protect the public. And protecting the public can also involve upholding the reputation of the medical profession. So it's not simply protecting individual patients. It's standards and wider. Yes, and those are the sort of cases where people find that they don't necessarily agree. Yeah.
Do you always come to one decision by the three members, or can you have dissenting?
There's no dissent. It's a bit like, in my experience of the Court of Appeal Criminal Division, what you find is that you come to your own view and then you meet and you're pretty much always in the same ballpark, and maybe there's a slight difference here and there, but overall it's not something that anybody would feel necessary to dispute. I don't think we've had any. One or two, but they're not actually dissenting judgments.
No, so it will never end up in the public domain. It will always be a decision that looks unanimous to you but might be majority, but we don't even get told sort of how they voted within the room. I've just been today updating the guidance for managing hearings, and sort of actually your job as chair is how long do you have to actually make these deliberations and managing time effectively. And if you haven't got that sort of unanimous agreement, you can't just sort of have an open-ended amount of time spent trying to get to that point. You have to at some point accept that you might have different views, and there's three of you, so two of you are going to be in agreement, and one will be the minority that has to accept that joint view.
It doesn't often happen.
No.
And one of the things that we're bringing in also is sanctions, bandings. They're not like sentencing guidelines, but it's really to ensure that there is consistency and openness and fairness, so that everybody has an idea of what the sort of ranges of sanctions might be. So, for example, you don't get no action for a serious sexual harassment in the workplace. Not that would happen. Yes.
Do you know what percentage of members are represented and how many represent themselves in the tribunal?
I think my last count from a formal report, we were probably about 23-ish sort of percent of self-represented. Probably one thing to note, thinking about sexual misconduct cases, is that if you do have a doctor who has a case of sexual misconduct, and therefore there are vulnerable witnesses that need to be cross-examined, we will instruct special counsel for that part of the hearing as well. So that assists. But yeah, 23%. So I do think sort of that's one.
That's across all hearings.
Across all.
I think it's less
just
the case for MPT cases. I think it was around 16%, which is actually quite a bit. But a lot of doctors are very articulate and want to represent themselves. Some have had insurance and it's not being continued through to the hearing. Those are some of the reasons why they're representing themselves. But you wouldn't know that for obvious reasons.
And when we list the hearings, if we know that the doctor is self-represented, we'll add additional time onto the listing, knowing that it does take you perhaps longer to manage them directly.
But it's actually, I think, a very good way of dealing with or learning, if you've not done it before, while sitting, of dealing with litigants in person, because you've got people who are intelligent and have thought about their case. They may not know how to best put it, and that's really where you are with litigants in person, I think. But one of our aspects of our research shows that the thing which affects outcome more than anything else is not any protected characteristics or anything like that. It is being represented and engaging. In a sense, it's self-evident, but it is the case. Anything else anybody wants to ask? Is there anybody online? I can't see.
Say, Emily, are people online able to ask questions?
Yes, they should be able to. They should show if you have any questions, and you can just ask them.
Because it's not showing up on here.
Ability to put questions up there if they want to.
If anyone online has any questions which haven't already been asked, do you put them in the
Should be a chat.
chat? You can find it. Is there no chat box?
There. There's a little box there.
Ah, here we are.
There's a little one there.
Okay.
Oh, we have got questions.
Excellent. So I'm just going through the questions which you've asked. I think, is there a fee for preparation time we've already dealt with? I'm going to answer the question which is about the practice background. We are very interested in people who want to sit. So do feel that you can apply. If you don't succeed, well, that is something which you will no doubt want to follow up. And I think that this is a good place to start if you haven't sat before and are thinking of sitting. So I think I would encourage everybody to have a go. I'm obviously not promising anything to anybody, but I think it's a fair and open competition, and certainly we accept applications from anybody over 5 years core. And as I say, you do get a lot of assistance and training. So just scrolling down. The question, do most LQCs have experience of being advocates at MPTS tribunals prior to their appointment? The answer is no. I think we have a very wide range of LQCs, not all obviously from the bar. People come from different legally qualified backgrounds. Don't feel that because you've not been involved in a tribunal you shouldn't apply. And hello, John Coughlin, KC, a member of my ex-pupils. And he's asking, is the box work or procedural paperwork or hearings, or do the LQC sit solely on the substantive hearings? There's no box work. And really any preparation work would be for the hearing that you're about to do. So thank you for that. Somebody's asking whether, if one of your relatives acts as an expert for the GMC, whether you have a conflict and your application would be precluded. Well, the answer is no, because conflicts will be taken on a case-by-case basis. So obviously, if the case involved your relative, you wouldn't be sitting on that case. So other than that, I think it's not going to be a problem. Question, in terms of the application, is the form going to be available on the MPTS website? And is it competency-based? And is there any further guidance anywhere? So it is going to be competency-based, but Tamara, if you want to...
it's competency-based.
And there's criteria.
You can have a look at the criteria for tribunal members and qualified judges on our website now. That stands there always, and it talks about the ability to make decisions, have sound judgment, having some intellectual and analytical ability, being able to work with others because you're going to be working in a tribunal, having an understanding about equality, diversity, inclusion matters, those sorts of things. And it's all set out there. Actually, it looks very, very similar to anyone who has looked at judicial appointments committee. Years ago, I met with them when I was drafting sort of our updated process, and they look very coincidentally like theirs after that. But so that will hopefully give you a good understanding. But when we go live on Friday, there's also guidance about completing your application form. And I do really encourage people to read it. I do it because I want people to do good applications. So just simply saying, I'm a judge, it isn't going to score highly, but obviously being able to talk about your particular experience of case, anonymised, etc., that you've been involved in, will hopefully articulate sort of your strength experience in terms of particular areas we're looking at.
Yeah, I found it quite easily on the website, which is a miracle because I'm completely inept at these sorts of things normally. But it is a competency-based application process with, exactly as Tamara said, the sorts of criteria in any application form that you might be filling out for a part-time judicial role or otherwise, or Silk's application form. It's the same sort of thing. So nothing will be of any surprise to anybody who's even embarked on that kind of process before.
Yes. Anybody else? I've gone through all of the questions online, so if there's anybody else who wants to ask one, here we are. And if not, thank you very much.
Well, no, thank you, Deborah and Tamarind, for joining us and enlightening us as to what looks like a fantastic challenge for anybody who wants that experience of sitting and also going to Manchester. So thank you both very much indeed on behalf of both PIBA and the PMBA, Emily and myself. We're incredibly grateful. And anyone in this room who's been here and listened this evening, go forth and spread the word, because I'm sure there are lots of very engaged, because it's 5 years PQE, yes. So actually you can be quite junior, and if you're brave and you want to put yourself out there, you get some really good experience. You don't have to be quite as long in the tooth as I am to even think about dipping your toe. So go forth and spread the word. But thank you both very much indeed. And I think, Emily, it's time to lead us through a double door.
Yes, I think double. Please open the double doors and have a drink. And also, if anybody knowing the BSB were checking up on CQD, if anyone wants to sign, I promise to keep a record, and then if you're checked up on, we can produce it. So thank you very much. Sign up at the back, and I'll